Hello everyone, it's time to record my latest question and answer session. This is the 11th one that I've done. So without further ado, I'll get into the questions. So I've front loaded a couple of questions from critics because I'm always accused of not answering these questions. I don't know why, because I answer them frequently. And then we'll get into more stuff about Lucy and her case. What do you think of the latest crime scene to courtroom videos? Well, I would liken them to reheating last week's dinner when last week's dinner wasn't that great to begin with. What is your medical training and when did you become a neonatologist? Well, I think I've said many times, in fact I know I've said many times on this channel, that I'm not an expert and I don't claim to be an expert. In fact, I've made it clear on many occasions that I'm not really a scientifically minded person. I've always been interested in the arts, and that if I have an area of expertise, is my area of expertise. I don't claim to have any form of medical training. That's why I'm so fundamentally reliant on speaking to experts, and that's why I've made so much effort to come into contact with experts, and I'm now very fortunate and very privileged that I know many, many doctors, professors, neonatal nurses, etc. And when I make medical assertions on this channel, almost without exception, they have come from other experts. I think there are one or two possible exceptions. A couple of things that have been stated by the prosecution and police are so ridiculous that you don't need any medical training. And I probably picked up on a few things via research here and there. Let me give you an example of one of the things that is asserted that is particularly ridiculous. This idea that when a neonate collapses, it's always predictable. Now, the first time I heard that claim, I wouldn't say that I knew it was untrue, but I thought, well, it's very, very likely that this is untrue. And it took a rudimentary amount of research to confirm that, of course, it is untrue. So I typically don't make medical assertions unless they're backed up by research and unless they're backed up by particularly expert opinion. And of course, I'm very fortunate that I'm in contact with doctors, professors and nurses literally on a daily basis. Like every day I'm talking to people and getting new contacts and receiving emails and so forth, and you'll be seeing some new experts on the channel in due course. So I don't claim, unlike Liz Hull appeared on stage. I think it was at the University of Manchester. It may not have been. I apologise to the University of Manchester if it wasn't. But she appeared on stage. She was being interviewed by a journalist. The journalist said, "You were in court, Liz," as if we didn't know that already. And so therefore you're an expert. And then when Liz Hull answered the question, she didn't correct her. She didn't say, "I'm not an expert. I don't actually know my arse from my elbow." She allowed the interviewing person to say that she was an expert. I would never allow that. I don't claim to be an expert. And if someone said that I was an expert, I would correct them. I do have a lot of knowledge about the case. I do have a pretty good memory as well. But I never claim to be medically trained or to have any degree of medical expertise, because that's simply not true. That's why, unlike people who are critics of myself sometimes, I actually speak to people who do have medical qualifications. How can you comment on this case when you didn't attend the trial? So there's two things that I would say to this. The first thing is, if you were to ask Liz, I was in court every day, Hull, about this, and if you were to say to her, what item of evidence that appeared in the court case, because I believe she was in court every day, I don't know if we've established that or not yet, but I believe she was in court every day. And if you were to say to her, which item of evidence that appeared in court that is not in the public domain convinced you that Lucy Letby was guilty, she wouldn't be able to say anything because it's all in the public domain by now. There is nothing of any substance that we don't know about. Of course, we don't know every single thing that was said, but we know all of the critical arguments and we know all the details around those arguments. That's the first thing. The second thing is that I've seen a lot of the court transcript. I could probably get all of the court transcript one way or another, but I just work on bits and pieces. I've seen quite a lot that I haven't dealt with on the channel, and I try to introduce that where possible, but I have seen a lot of the court transcript. Where I haven't seen the court transcript, of course, there's court reporting. You shouldn't rely on the court reporting alone, because we've found on several occasions that the court reporting doesn't give a full and proper picture of exactly what occurred in court. So I do try to get hold of the court transcripts where possible, and a lot of that is now available, and you've seen me analyse the court transcripts on this channel. The third thing I would say is that the focus of the person who asked this question shouldn't be on why I didn't attend the trial. It's obvious why I didn't attend the trial, because it went on for 10 months and it's completely impossible for anyone who isn't getting paid or possibly some retired people to attend every day. It's just preposterous suggestion. In fact, I never even heard of Lucy Letby until the conviction as well, so there was no reason for me to attend the trial. But even if I had wanted to attend the trial and every single day of the trial, which is completely logistically impossible, I obviously couldn't have done it because I don't live in Manchester and I don't have an independent fortune. So it's a kind of ridiculous requirement in the first place. But what you should actually be concerned with is why you, as a human being, fund the court system, pay the barrister's wages, pay the judge's wages, pay for the police, and then this thing that you've paid for goes on behind closed doors, and then they all come out and say, oh, the hoi polloi, the great unwashed, they don't need to hear about any of this. We don't need to have any transparency, and if anyone questions us on this, we will just say, oh, well, you weren't in court, so you don't know what you're talking about. That should be what you should be reflecting on, the fact that you're essentially an apologist for elitism. I'm not an apologist for elitism. I recognise elitism when I see it, and I always call it out. If the defence, I think this probably means the prosecution, it's just miswritten, but were instructed to obtain a nurse and an obstetrician as expert witnesses but did not do so, could that be an issue for appeal? Shuley's performance clearly shows how important both were. Without a forensic toxicologist and a very experienced neonatologist, could that be considered a disqualifying issue? So it's certainly an element of the highly flawed, to put it generously, investigation that could be highlighted in an appeal. And it's, I expect Lucy Letby to be given leave to appeal. I hope that happens soon. I don't think it's something that would just, the implication here is that it would automatically allow Lucy's appeal to be successful. I don't really envisage that as being likely. I think overturning this conviction will be death by 1,000 cuts, and you'll have to put forward many different arguments. I think what the court will say in particular is that there were experts in court, and they were legitimate experts. They will consider Dr. Evans to be a legitimate expert. Indeed, the previous Court of Appeal verdict indicate he was a legitimate expert. So I know people are always kind of seeking a silver bullet to overturn this. I just don't see that happening. It's going to be a lot of effort from a lot of people over a concerted period of time, lots of experts, and a big, very well joined up effort at the Court of Appeal. Was Dr. Sandy Bohin asked about the RCPCH report or whether she had expressed concerns about the same issues of professional competence that Shuley highlighted and which Dewi Evans did not? No, she wasn't asked about this because the RCPCH report was excluded from the court case. She will have been asked questions and was asked questions about professional competence, about issues on the neonatal unit, but both Evans and Bohin repeatedly hand-waved any suggestion that there were mistakes at the counter chest. Dewi Evans in particular made it sound like an exemplary neonatal unit, and we know for a fact now from the leaked police documents that he never made any effort to look for any issues at the hospital. Dr. Sandy Bohin was just pretty much his parrot throughout the court case, who hardly ever, if at all, disagreed with anything that he said. So the idea that she's going to contradict him and say, yeah, there were massive problems on the neonatal unit, it just didn't happen. But they weren't allowed to be asked about the RCPCH report because the judge ruled it as irrelevant to the court case, and so it couldn't be referenced. Surely a professing neonatologist backing up the chief non-specialist witness would be a relevant source of unbiased concern about the resuscitation issues on the RCPCH concerns. So I think in the rejected cases that the Crown Prosecution Service has put forward put forward by Cheshire Police recently, I'm pretty sure, obviously they've denied this, so we can't say for certain, but I'm pretty sure the Crown Prosecution Service will have looked at the wealth and depth of neonatal experience that any prosecution case would be up against and thought, well, there's nowhere we can put this in court. So I think in a future retrial, should such a thing occur, and a retrial is certainly not inevitable, I think at that point the court will hear, as you say, relevant information about resuscitation issues, concerns. Now, it would be interesting to know if there is a retrial, whether the Royal College report would then be considered relevant. I think a judge would probably be conscious of the fact that there'd been significant and justified criticism of the previous judge for not allowing the Royal College report to be in the original court case. So it may be allowed in a retrial, but certainly when you get this powerful phalanx of neonatal expertise in court, it's going to change the process completely. Of course, we can say with absolute certainty, I would say 99% certainty, we can say with absolute certainty that if you'd have had this incredible array of expertise in the original court case, Lucy would never have been convicted. You'd be looking at a very different process. Did anyone in Cheshire Police have a financial incentive not to hire the required experts? Is there any evidence of fraud on the part of Cheshire Police? So I fully believe, when I say fully believe, I'm virtually 100% certain that Cheshire Police did the best that they possibly could in the investigation, and they genuinely tried their hardest. And when Lucy Letby was convicted, they believe that they've done a good job. They may still be deluding themselves to this day that they've done a good job. They may still be deluding themselves. It certainly seems that they were, based on the statement that they put out, that the cases they sent to the Crown Prosecution Service recently, that were very recently overturned and rejected by the Crown Prosecution Service, they may still consider those to be legitimate, and they may consider they did a good job on those cases. I can't really comment on the financial incentive thing. It is just a bit of a shaky area for me to comment on. I think we have to assume that Cheshire Police acted in good faith, and I do believe they tried their hardest in the investigation. They just did a lousy job due to a combination of ignorance and stupidity. Is this the longest, most branched and most clearly signposted but wrongly route-selected garden path you ever seen or heard? That's a good question. I'd have to give some thought as to whether I could think of another scenario that had been so calamitously, catastrophically incorrect, and that had been so meandering and so many people involved. It's difficult to bring one to mind immediately, I'll say that. A couple of things that have just come to mind were McCarthyism in the United States. That was a pretty calamitous period of history where something that just had no foundation went completely out of control. I think there are similarities between that and what occurred here. I suppose there are many others if you look in that period of history, there's the Manhattan Project, which obviously had very serious consequences. I mean, I've mentioned before, I was always very fascinated by nuclear war when I was a kid. I've just been watching When the Wind Blows recently. I don't know if anyone's seen that film by Raymond Briggs, absolute masterpiece. I really recommend it. It's on YouTube. You can watch it. Bit depressing, but I mean, it's a real masterpiece narrative. It's truly moving and powerful piece of work. So those would be a couple, and then of course the obvious one from this country, if you're talking about this kind of meandering characteristic of the Lucy Letby case, would be Hillsborough. I think Hillsborough was, although it was very obvious, I think early on what had gone wrong with Hillsborough. It obviously took so long for any form of justice. Obviously, I don't believe true justice has still occurred with Hillsborough, and it just went on for decades. And the families had to fight and fight and fight, and there was so much misdirection and misinformation and lying, indeed. So maybe that would be a good comparison. How could a journalist who was in court every day for 10 months miss a nurse speaking honestly for weeks and not realise that the chief witness was not a perinatologist? So there are several possible answers to this question. I did mention recently that Liz Hull, for example, I think this is the journalist you're probably referring to. She said after the prosecution case that she decided Lucy Letby was guilty before she even heard the defence. Now that doesn't indicate a very high level of professionalism. The other thing she said was that the jury would really need to like Lucy Letby in order to exonerate her. Now, there may be an element of truth in that, but that indicates to me far too much of an emotional involvement and far too much of an investment in personality and character and presentation and emotion. Now, I'm not a person who's bereft of emotion, not at all. In fact, I consider myself to be emotionally intelligent. But in that situation, I know I should rely on my intellect and on reason and on rational arguments, not these kind of emotional indicators, because they're not reliable. I mean, Ollie Buxton, Jolly Contrarian, was talking about this, how we're really bad at reading people. Like, it's known to be the case. Like, everyone thinks that they can read people, and sometimes we can, but sometimes we read people really badly. Let alone someone we don't know who's in a really stressful situation, who's across a courtroom. How on earth can you possibly hope to read that person? And yet both Judith Moritz and Liz Hull seem to think that they can read Lucy Letby like a book. I mean, I find it preposterous. I do think it's kind of significant that they're both female. It's been interesting to have this Ian Huntley thing in the news recently, because coincidentally, I grew up around the same place as Ian Huntley, and also coincidentally, Andrew Malkinson grew up around there. And when the Ian Huntley stuff came out, unfortunately, I was still living there, and it was in the local press like every day, and people were talking about it all the time. And Maxine Carr got such a hammering, and perhaps some people watching this video think that was deserved, but I think she was simply very scared and afraid of Ian Huntley. Now, whether what she did was right or wrong, obviously it was wrong. But when we're living in fear of someone who has indeed murdered people, perhaps it's understandable that they might behave in a way that is less than ideal. With that being said, I mean, I used to know a woman, and I used to like her. We used to get on, but she absolutely despised Maxine Carr and almost held her more responsible than Ian Huntley, even though Ian Huntley obviously killed the infants, Holly and Jessica, isn't it? I think their names were. And yet, you know, she'd go on and on about Max. She was more angry at the woman. And I think, I don't want to be engaging in pop psychology here, but I think that, you know, both Judith and Liz are expecting some sort of outpouring of emotion from Lucy, and when they don't see that, they seem to judge her for it. In a way, they seem to judge her more harshly than male observers do. And I think some of that may be related to maternal instincts. And I know Liz, she had I believe she had one of her children was born at the Countess of Chester or in Chester, but I believe it was the Countess of Chester. And, you know, she talks about crying in court. I mean, I can say pretty confidently that I would not have cried in court, and that makes me sound really cold. But I would just be focusing on the evidence and the facts. Of course, I know there were some extremely harrowing accounts, and I'm not saying I wouldn't have been moved by those, but I've always got my thinking cap on and my rational hat on where possible. Of course, I'm not immune to emotion. I'm not immune to being, I'm not completely objective. No one is. But it seems to me that it's deeply inappropriate for journalists to get that emotionally involved in a case. But I think I do think that perhaps that is due to a certain maternal instinct that has to be very, very strong, because women have to go through childbirth. I'm not saying there isn't a strong paternal instinct, and I'm not saying that males that have children watching this channel and indeed in the wider society don't really, really care about their children. But as parents, we men do get it a little bit easier, because we don't have to be pregnant, we don't have to go through gestation, we don't have to go through childbirth, and we don't have to risk our lives, because there is still a small risk of death in childbirth. So in order for women to go, if they looked at it objectively, they would just say, well, I'm not going through all that, obviously. So there needs to be a very, very strong maternal instinct. So I think perhaps that's why women who are observers of the case can sometimes be harsher critics of Lucy Letby. Conversely, I think that's why also some of the biggest defenders of Lucy Letby are female, because they know what it would be like to have a daughter in those circumstances, and they probably relate to her going through those circumstances. They know what it would be like to be a young woman in that position, etc., etc. So I think somehow Liz and Judith were expecting certain things from Lucy Letby that they didn't see, and because they didn't see those things, they judged her very harshly. That's the kind of best answer I can give to that question. If you have any feedback on that in the comment section, I'd be really interested to hear, because it's a difficult question for me to answer, and of course I am speculating a little bit, I think, there, because obviously I'm not a woman and I don't have any experience of being a woman. I don't have any memories of any past lives where I've been a woman, if indeed that has happened. So I have to go on my male experience and my observations. The last thing I should say is that please remember that Josh Halliday, who's now changed his mind ostensibly, according to what we've seen in a documentary, he sat through the court case and he believed that Lucy Letby was guilty. I really genuinely believe that if I had sat through it, I would have thought she's not guilty beyond reasonable doubt. I really believe that. But I obviously can't prove that. I might have been taken in by it as well. It is very difficult. We know it was a difficult case for the defence to fight. We know that there were problems with witnesses. We know the prosecution used a lot of what I consider to be dirty tricks, but are probably pretty normal in court cases. And we know Dr. Evans was willing to get in the witness box and say anything. So it was very, very difficult, and the prosecution successfully pulled the wool over a lot of people's eyes. And, you know, I can be a little bit harsh, I know, to Liz on this channel, but we should bear in mind that it was a very difficult process to go through, and the prosecution is trained. They're in the business of convincing people. They convinced a lot of people, and the journalists who were in court were among them. Sorry if that was a long answer, but I got a bit philosophical there. It just seemed like an interesting question, and tried to address it as thoroughly as I could. Why did Ben Myers not call the coroner to state that the deaths were from natural causes? I suppose the short answer to this question is I have absolutely no idea. As far as I know, he could have done, and that would have been a good idea, obviously. It certainly would have helped in some of the cases, wouldn't it? And then he then could have passed that into other cases, talking about her embolisms and so forth. There's a possibility that it was part of the pre-trial agreement not to talk about the coroner and not to talk about the coronial process. I don't know if this is the case or not. All I know is the coroner was never mentioned in the court case as far as I'm aware, based on the best information that I have. In 30 interviews, say around 100 hours with a nurse speaking openly and not evading questions, how is it conceivable that investigators did not seriously entertain two reasonable possibilities? First, that Lucy Letby was telling the truth, and second, that no crime had been committed. So the first thing is I should just say that the interviews lasted for 23 hours, so not quite as much as 100 hours, but still plenty of time to ascertain what you have described here. It's hard to give a definitive answer to this question because I don't know the interviewers personally. I've seen evidence of their intellectual level, and you've heard Stephanie talk about this as well, and I agree with her. I don't think it's particularly high, and we've seen the extent to which confirmation bias riddled the investigation. Unfortunately, they thought they were doing a good job. They thought they were investigating properly. They thought they were being thorough. They thought they were being objective. But I was talking about this the other day. One of the problems you have is that stupid people never know that they're stupid, or they find it very difficult to know that they're stupid, or that they're not particularly bright. So they can think they're doing great things, and they can't see all the problems with what they're doing. This is one of the reasons that particularly high-functioning individuals can often struggle in life. They often find it really difficult, and unless they can find a solitary occupation or a solitary profession, they often find it very, very difficult within any kind of employer or any kind of system, because no one can understand their ideas. They constantly have to explain things to people of lesser intellect, and they can't understand what they're talking about. And they can't see that what is obvious to them is not obvious to other people. So then they end up discussing a load of things that have nothing to do. So these are well-established, studied problems, and you almost always find that very highly intelligent people become somewhat alienated, or go into very individualistic, solitary, almost solipsistic existence, because they can't function within a system because the system can't understand them or deal with them and doesn't know how to deal with them. Conversely, you will often see in systems people of moderate ability being promoted beyond their means. And with the greatest respect to Mr. Hughes, there can be no clearer example of that, in my eyes, than Paul Hughes running this investigation. I don't wish to be nasty about him, and I try not to do that. I know I've said some stuff that is confrontational with regard to several people, probably most obviously Dr. Evans, and he deserves it, so I'll make no apology for that. But I do believe Paul Hughes tried his hardest, but he just was not up to running the investigation. And I just think intellectually he was never going to be able to do it, and he should never have been promoted to that position. But they might have not have had anyone better, because I wasn't exactly impressed with the intellect of Simon Blackwell. I wasn't exactly impressed with the intellect of Daniel Stonier. I'm not sure we've heard, well, there's other officers in the Operation Hummingbird video. Most of them are like family liaison officers, aren't they? I don't think we've heard that much from Nicola Evans, but I think a lot of it just simply comes down to that. They just cannot understand the case. They can't understand the case, and they can't understand that what they're doing is biased, and they can't understand they're not being objective, and they can't understand that they're not following natural lines of inquiry. Now, what I will say is that Dr. Steve Watts has taught me a lot about the police and given me an enormous amount of information, and I haven't even scratched the surface of what he's given me. And you will well know I've interviewed him for this channel. He's been on the channel a few times now. I've spoken to him quite a bit. We're not even, and obviously I've done quite a few videos on the police, I should say as well. We've not even scratched the surface of what I've got on the police. And it's like anything. I never want to just relentlessly talk about the police. I mean, I could do, for example, Johnson's closing statement and just do it from the start to the end, video after video after video, but that would be a bit relentless. And I try to make it interesting to watch. So I'll dip into things, then move on to something else, and then revisit them later on. But I mean, I've made 170 videos. I've done over 200 hours of video. I can easily make thousands of videos about this case, easily. And so what Dr. Steve Watts has told me, why they didn't follow what he has shown me, basic protocol, basic procedure, I have no idea. There is no good answer to that question. It's just simply incompetence. Are there grounds for Operation Hummingbird to be investigated by the Independent Office for Police Conduct? I don't think that the operation itself would come under the auspices of that, because I think they tried their best, I've just explained. I think perhaps some of their conduct since the conviction of Lucy Letby could be grounds to be investigated, but it seems to me that the Independent Office for Police Conduct is a pretty blunt instrument that doesn't really want to investigate the police. Does the current system of expert witnesses allow too much room for bad faith actors? So I'll answer that question before I go on to the next one. Yes, clearly. Should experts be profit-driven or treated as beyond reproach? Absolutely not to both questions. The problem is that we do see expert shopping. It's ironic that supposedly the appeal system doesn't like expert shopping when court cases themselves are absolutely based on expert shopping. That's deeply ironic. I'm sure you'll agree, but it's clear that the whole system for selecting expert witnesses needs fundamental reform. Hopefully that will happen. I don't have an enormous amount of faith that it will, because once there's a system in place, people just want, particularly people that have to make decisions, they just want to continue with the existing system. They just say, oh, it's what we've always done. Look at all this stuff we've put in place now. It's too difficult to untangle it all. Let's just continue as we are. So there will be significant institutional resistance to changing anything in the system, let alone something as fundamental as switching from an adversarial to an inquisitorial approach. I mean, I just don't expect that to happen in my lifetime. Maybe one day it could happen, but I don't expect it to happen quickly, if it happens at all. Whether or not the expert witness system can be tweaked or fundamentally reformed, I don't know. Whether even the Law Commission's recommendations from 2011 will be enacted, again, I don't know. I hope that some of these things will happen, and I will be hopefully a voice advocating for this. But I'm obviously small fry compared to the people that make this decision, and while there is very clear evidence that the expert witness system needs fundamental reform, I'm not sure whether or not it will happen. Given the apparent evidence suggesting malpractice and scapegoating, is there a legal basis for bringing the matter back to court? So it's difficult to prove, as I've discussed this quite a few times. A lot of these things, while it can be inferred that these things have occurred, it's very, very difficult to prove that someone isn't acting in good faith. This is why perjury is very difficult to prove. There usually needs to be explicit evidence that someone wasn't acting in good faith. I'll give you a good example, although it's not an example of perjury. But the gentleman who drove the car, he was the driver for Joanna Dennehy, who stabbed various men to death and rightly went to prison for a full life sentence. The driver wrote a letter to Joanna Dennehy that was intercepted by the prison because they read everything. And in this letter, he contradicted the entirety of his own defence in court. Now, obviously, he's already in prison, so I don't know if there are any real consequences for that. But that would be cast iron evidence. So, in a case of perjury or in relation to the question that's being asked here, if someone wrote down, oh yeah, we deliberately scapegoated Lucy Letby and we deliberately targeted her and the reasons for this are as follows, and then someone found that note and you could be proven that it had been written by someone at the hospital, that would be evidence for perjury. Beyond that, it's very difficult to prove perjury, and of course it's not ideal for Cheshire Police to be the investigators. I think there is no, unfortunately, legal basis for bringing the matter back to court based on malpractice and scapegoating, because it can be honest errors and honest mistakes, and it's very difficult, if not impossible, to prove otherwise. Did Lucy Letby have a solicitor present at all three of her police interviews who could have challenged questionable police tactics? So as far as we know, the answer to that question is yes. She certainly had a representative. Former solicitor Lulu Mins informed me that it's not automatic that you have a duty solicitor accompanying you. Sometimes, I forget exactly what she said, who the replacement person could be. Sometimes you have someone in attendance who isn't a solicitor, but she certainly definitely 100% had a representative. And for allegations of this magnitude, it's extremely likely that there was a solicitor present. So you're absolutely right that I don't know what a solicitor said to her, but she was very, very poorly advised, to put it mildly. What role did the BMA representative at the County Chester Hospital, Dr. Sean Tighe, play at the time? So this is a very good question. So we'll go through some documents to assess this. So Sean Tighe, I assume that's how you pronounce his name, appeared at the Thirlwell inquiry, and I'm not going to go over everything that occurred. I'm not going to go over all the documents from the Thirlwell inquiry that mention his name. I'm just going to read this from the London Evening Standard. So before I read this, I'll just warn you that it will make many of you very angry. Among those at the meeting was consultant anaesthetist Dr. Sean Tighe, who was asked to attend as a witness in his role as union representative for the doctors. Asked about Letby's statement, he told the inquiry, well, I thought it was completely inappropriate. We'd been told that the meeting was to explore the reports, the contents of the reports, and to explore the possibility of Ms. Letby returning to work, not to hear a 20-minute melodramatic dissertation from Ms. Letby herself. Dr. Tighe said the consultants responded by completely denying they had made any derogatory remarks, which Mr. Chambers demanded they apologise for. And so it goes on, they talk about the inquiry and the Thirlwell inquiry. Now, I'd say that these comments are highly biased and bordering on despicable. I'd put it to Mr. Tighe, or Dr. Tighe if he prefers to be addressed that way, that if he had been accused of murdering patients and thrown off a neonatal ward and had his employment put into serious doubt, and then somehow he has to go back and work on the unit where people have been accusing him of killing babies with no evidence, as we know, would you describe... I'm sure Dr. Tighe would want to have his say on the matter, and I'm sure he would not describe him expressing his feelings and his views as being a melodramatic dissertation. But of course, Dr. Tighe is completely biased because he's a union representative who's there to represent the doctors, and therefore he is utterly sympathetic towards their perspective and just kind of bereft of any objectivity. So I don't really want to say any more about his role than that, but you can imagine what he was involved with at the Council Chester Hospital. If an appeal is allowed and a retrial called, what happens if the prosecution cannot find medical experts willing to support the claims that babies were murdered? Well, theoretically, they can still continue with a case. It's not requisite for them to have medical experts in court. Of course, it's going to look pretty bad for the prosecution if they can't put a single medical expert in court to support their case, and then they're up against 31 experts, and it'll probably be more by then. But theoretically, they could continue, but at that point, there's obviously a very good chance that there wouldn't be a retrial. Whether or not they will be able to find any, I think it's not inconceivable that they would, because there'll be a lot of money in it, potentially, and someone out there might be willing to try and put something together and try and stand in a court and say something, if there's a big enough payday. But I think it's going to be very difficult to find, certainly, many medical experts that are going to support the prosecution. And really, if the prosecution is going to have any credibility, they're going to have to suggest the same methods of malfeasance that occurred in the first trial. And so someone, either a paediatrician or neonatologist, is going to have to suggest that, oh, it wasn't a bowel obstruction, it was air. It wasn't a delay of antibiotics, poor care, pneumonia, respiratory distress and infection, it was air. It wasn't a gastrointestinal hemorrhage that caused a bare minimum 25% blood loss, it was air, and Lucy Letby used an indeterminate tool, and so on. It's going to be incredibly difficult to find someone who will say that, that's for sure. Would the prosecution then have to subpoena Dr. Dewi Evans, and if so, would he have to justify his various theories under scrutiny from more qualified experts? So they wouldn't subpoena Dr. Evans because the prosecution want to try to win. So there's no prospect they would do that. Dr. Evans will not be in the retrial. I think it's highly doubtful, or certainly somewhat doubtful, that Dr. Evans will appear at the Court of Appeal, because he's a liability to the prosecution, and in a retrial he'd be an enormous liability. So there's no chance Dr. Evans will be in a retrial because the prosecution wants someone to be in court who's going to help them, not hinder them. The staffing graph produced by the police has been described as misleading by professional statisticians. Why was it accepted as evidence? I think that the simple answer to this question is that most people's understanding of mathematics and statistics is very poor. I've mentioned a few times having this discussion with someone on Reddit where they said, I was trying to explain to them that if there's a 1% chance of something happening, then it means it will happen a lot within a massive system like the NHS. And actually, I did manage to explain that to them and they did understand. But their initial instinct was that if something is happening 99% of the time, it means that the 1% of times when it's not happening is so trivial as to be meaningless. But of course, that's not true. So that's just one example of how people's grasp of statistics can be very poor. It may have looked at convincing evidence to the Crown Prosecution Service, and therefore they've accepted it as evidence. And once they accept it as evidence, the prosecution adopts it, and then it's in the court case. And I would say that is just simply another example of ignorance in this overall debacle. Following any retrial, will the public inquiry examine the conduct of Cheshire Police and the accuracy of witness statements that may have been untrue? So I would hope there will be an inquiry into the conduct and also investigative capabilities of Cheshire Police. Now, I've mentioned before, the police usually weasel their way out of any situation, so I don't expect Cheshire Police to face serious consequences for their piss-poor investigation. In terms of the accuracy of witness statements, there's no doubt that, I mean, this kind of tacitly references Dr. Jayaram in particular, I would think. There's no doubt that Dr. Brewery and Dr. Jayaram will face significant scrutiny. I personally don't expect them to go to prison. I'm sure they'll manage to weasel their way out of it. It's very difficult to prove that there was any perjury or that they acted in bad faith or that they've committed a criminal offence, but they will face massive scrutiny and they'll probably never recover from it. Do you think the Home Office will reorganise constabularies, possibly merging Cheshire Police into a larger force? Well, the first thing that I would say to this question is that I'm not really well qualified to answer this question. There's always a kind of push for centralisation at the level of government because it's just easier to manage things that are centralised. I'm generally not in favour of centralisation. I'm in favour of devolution of power and more regional representation. So I wouldn't be in favour necessarily of merging Cheshire Police into a larger force, because I think the larger things become, the less accountable they are, and the more unwieldy they typically become, and then the harder it is to break them up and the harder it is to hold them to account if they do anything wrong. So I wouldn't necessarily be in favour of that. I would hope that the Home Office, the state, the government, however you wish to describe it, the authorities broadly speaking, will certainly hold Cheshire Police to account and inquire into the matter of how their investigation was so incompetent. Some of their conduct since then certainly shouldn't escape censure, but usually the police do get away with doing whatever they wish to do because it's just such a difficult nettle to grasp to do anything serious in terms of punishment to the police, because they still have to have the credibility to enforce law and order within the region in which they're operative. So if you take away their power, or if you seriously undermine them in any way, then how do you deal with day-to-day crime? Whether or not they could be absorbed into a larger force, it's the kind of thing that the state and government like to do, so it's probably quite conceivable, but I wouldn't necessarily welcome that myself. Who received the money from the Netflix documentary? Well, I'm not entirely sure about this because there hasn't been an enormous amount of transparency, not for the first time. The Netflix organisation, the people that were involved with the making the documentary, do describe a tendering process. So that would suggest that Cheshire Police benefit from this commercially, but they themselves have denied this, so it's very difficult to say whether money changed hands and what happened, etc., etc. And I couldn't really say with any confidence what the answer to that question is. Which documents relating to the arrests, trial, and evidence are available to the general public? So, I guess that's quite a difficult question to answer succinctly, but I suppose you could argue theoretically the entire court transcript is available to the general public because you could theoretically buy it, but it's not available in the way that I believe it should be, where it's funded by the public, the court case, so therefore it should be public property, not just publicly available. In terms of documents relating to the arrest, none of them are available because getting police documents is really hard. Some have obviously been leaked, as we know, but typically it's very difficult to get information out of the police, even via freedom of information request, because they just block everything. And to be fair, I don't think it's too strong a statement to say that they believe they're above the law. In terms of the evidence, we've got the Thirlwell inquiry. There's obviously quite a lot of the court case available, and you could get the transcripts and so forth. It's difficult to get hold of reports, and it's difficult to get hold of stuff from the County Chester Hospital that's not already in the public domain. There are quite a lot of documents available, but then there's also quite a lot of documents that we haven't seen. And I should mention the Thirlwell inquiry has both suppressed documents and also declined to publish large portions of even the available documents, because you'll see like 1 page out of a statement of 8 pages, meaning that all the other 7 pages have been redacted. And I know that for a fact they've redacted entire documents as well. So there's a lot of evidence out there, but there's a lot more that we don't know and that should be available to us but isn't. Which documents allegedly cost £100,000 to obtain copies of? So this is not alleged, this is a fact. I've seen the email where this figure is quoted. This is a definite fact. And the £100,000 is just to obtain a full transcript of the court process. Absolutely ludicrous, disgraceful. This should be publicly available, and of course, as I've argued many times previously, court proceedings should be recorded as they are in other countries, and there's simply no argument against this. Was there really no official court transcript available? Well, there is one available. As I say, the £100,000 figure has been quoted. A lot of that is now in the public domain. We're getting more and more available. But, I mean, this just simply shouldn't be necessary. I've already made my views clear on this. In the hospital, regarding death rates, 8 and 5 deaths compared with 2 4 previously. What was the total number of babies treated in those periods? And is the difference statistically significant? A very good question. So let's answer the total number of babies treated in those periods first. We don't know because it's impossible to get information out of the Council of Chester Hospital. They really have battened down the hatches and won't say anything. One of the things that I've discovered from this court case and from researching the Lucy Letby case is that individual hospitals don't necessarily release figures on the number of deaths on various units in individual years. What we see instead are trusts releasing this data. So usually it's not broken down into individual hospitals, and it's very difficult to get this information for individual hospitals, certainly over recent years. I don't know if that has changed historically, but over recent years it's very, very difficult to get this information. So the answer to the first question is we don't know. We don't have precise figures on the number of deaths, let alone the number of babies that were being treated. In terms of whether the difference is statistically significant, we can't make an assessment on that because we don't have the data. In order to assess this, it would be necessary to have a full picture of the neonatal unit, a full picture of the babies, and so forth. At this point, I would just be speculating, as would someone who is more statistically qualified than me. So we just can't answer this question, unfortunately. During cross-examination, Johnson told Lucy, "I can show you the footage if you like. Did the prosecution have access to webcam footage earlier than the defence, and were the disclosure rules followed?" So whatever is available to the prosecution should also be available to the defence. So we don't know for certain, because you never know about disclosure, and it's clear that there have been some issues with disclosure in this process. However, it does obviously suggest that the prosecution deliberately misled the court and knew that Lucy Letby had been arrested in pyjamas. We don't know that for certain. We don't know what footage they had. We don't know if the police misled the prosecution. But certainly the police knew that what Lucy said, her account of events, was absolutely accurate. And I should emphasise as well, whether or not she was wearing pyjamas is not an important aspect of the story. The point that Lucy was making in her account, where she was being questioned by Ben Myers, is that it was a traumatic experience. We've all seen that on camera now, and we know that it was a traumatic experience, but frankly, you don't even need to see it on camera, because obviously being arrested first thing in the morning in your own house when you're not properly dressed, and then being told that you're going to be arrested with suspicion of murder, and then you're going to be taken away to the police station, you're handcuffed, it's not exactly going to be a picnic, is it? Even if you're guilty, it's going to be traumatic. If you're innocent, it's obviously going to be enormously traumatic. So her account was absolutely fair. If anything, she downplayed the amount of trauma, because she could have said, they barged in my bedroom at 6 o'clock in the morning and arrested me while I was still in bed. If anything, the account she gave in court was downplaying the trauma. So it's a complete nonsense argument, even if what the prosecution was saying is true, which of course is not true. When Lucy was moved from night shift to day shift before the unit was downgraded, was there any change in deaths occurring at night versus during the day? So I've specifically addressed this in a recent video, and this is another nonsense argument, because there were only... The argument is, deaths followed Lucy from night shifts to day shifts, but in fact, there were only 2 more deaths after Lucy was moved, because Lucy was moved in April 2016, and the only deaths that occurred after that were Child O and Child P. Child O, we know there were massive medical blunders, and Child P had a subcapsular haematoma. To say that was because of the changing of Lucy Letby's shift pattern is utterly ridiculous. So this is just yet another myth about the Lucy Letby case, the idea that deaths followed her from night to day. That didn't happen, that there is no statistical indication that there's anything significant about this. It's just mythology, poor argument, and just ignorance and a lack of understanding, I think, at times. Were the handover notes found at her parents' house during the second arrest? If so, why were they not found during the first search? So I believe there is evidence that some of the handover notes were found at her parents' house during the second arrest. I must say that I don't have an enormous amount of trust with regard to the police. So I don't necessarily accept their version of events. They could be true, they might not be true, they could be mistaken given the accuracy of other information such as the swipe card data they put in court. I don't really know exactly what's happened with the handover notes. You ask a very good question about why they wouldn't have been found during the first search. It does seem that some of them were found during a second search. All I will say is that I'm really quite tired of talking about the handover notes and the handover sheets. They're nothing to do with the court case. They're nothing to do with the allegations. They're not evidence in any meaningful way. I think I learnt recently that there were only 9 sheets that were actually related to collapses out of 257. So it's a trivial number. They're not a trophy. They're nothing to do with the allegations. They're just complete crap. I despair, and I feel one day I'll be lying on my deathbed in palliative care, and the nurse will say, "Oh, but Chris, what about the handover sheets?" And I'll have to explain to her. And Lucy will have been exonerated 35 years ago. It just has nothing to do with the case. It has nothing to do with the murders, alleged murders, I should say. It has nothing to do with the infants. It has nothing to do with the counts of Chester Hospital, what happened on the unit. It's just a complete nonsense that the police put in the court case because they're stupid. And people continue to repeat it as if it has some relevance. It has no relevance to anything. Whether or not Lucy should... Obviously, we know nurses take home handover sheets. That's undeniable. Countless of nurses have said this. Whether... I think it's absolutely obvious how these handover sheets ended at home. It's obvious she took them home by mistake. So they're just in her pocket at the end of her shift and she takes them home. There end up being too many. She doesn't throw them away. I've explained this many times. Whether or not she should have had... Whether or not there's too many, whether or not it's unprofessional, whether or not she should have had that many at home, I don't know. I don't care. I don't really care if she was a good nurse or not. There's evidence that she was a good nurse. But we all make mistakes. We all do things wrong in our profession. We're none of us are infallible. But if people want to judge her really harshly as a nurse based on the fact that she has some handover sheets, that's fine. Please do that. But it's nothing to do with the court case. All I care about is what happened in the period 2015 to 2016 at the Counts of Chester on the neonatal unit, which is nothing to do with notes found in Lucy Letby's bedroom that have nothing to do with the court case and nothing to do with the infants that are in the court case, with the exception of 9 out of 257. So approximately 3%. So 97% of them are utterly irrelevant, and even those that are still have nothing to do with the allegations. Why did a police officer in the Netflix documentary say the handover notes were filed chronologically rather than scattered in bags around the house? So there are 2 possible explanations for this. The first explanation is that the police were misrepresenting the way that the handover sheets were stored in Lucy's house and how they were discovered, and the second is that they don't understand the term chronological. Either of those are possible, or indeed both of them are possible. I really couldn't say with certainty. Can a coroner who possesses facts not heard in court raise doubts about a conviction? Yes, absolutely. There's no reason why the coroners couldn't have appeared in the court case, and of course they're allowed to use their expertise, and if they're in possession of facts, they absolutely should raise them. And as mentioned earlier, the defence could have called the coroners. I really don't have a good explanation for why this didn't happen. How many babies died in the 6 months after Lucy left the hospital? We don't know exactly, but we know that there were further deaths now. So the idea that there were no more deaths, we now know this to be untrue. But we can't say for certain. I kind of explained the reasons for this a few questions ago. It's very difficult to get this information from any hospital, let alone the Counts of Chester Hospital. If Lucy was allegedly harming babies to attract the attention of a doctor, what did that doctor's rota look like statistically? Was he present for every death? I mean, that's a great question. So we can say quite confidently no, because I think some rudimentary effort was made to look at the doctor's statistical presence at some point, but it is fair to say the nurses will be near the patients more than the doctors because they're the eyes and ears of the unit. So it's unlikely that a doctor would be around as much as a nurse. But you raise a very good point that if Lucy was doing this, then why is the doctor not there in a correlative fashion with Lucy's presence on the unit? Because it's a simple answer to that question is because it's complete nonsense in the first place. what it's nonsense for numerous reasons, but one of the reasons that it's nonsense is that Lucy didn't have to attract the attention of the doctor because she very evidently had his attention already. We don't know whether it was just a friendship, or whether he had designs on her, or whether she even had feelings for him. She obviously denied this, and for all we know, he might look like the back end of a bus, and she might think, well, I don't want that bearing down on me, thank you very much. But she might think he's a nice guy. I mean, whether she'd have those unpleasant and rather rude thoughts if he was a friend, I don't know. Clearly, she did have some feelings for him in some sense, even if they were platonic feelings, because she was upset by the fact that he has abandoned her and essentially stabbed her in the back. But the notion that she was harming babies is obviously rubbish in itself, but the idea that it was to attract the attention of a doctor is just completely ridiculous, given that he was already texting her all the time anyway. If 17 babies died while Lucy worked on the ward, but the police focused on only 7, what happened in the other 10 cases? So we can examine these deaths, or at least we can examine what Dr. Evans eventually said about the deaths. So there are 18 deaths on the unit, not 17, because there's one death that occurred in the Central Labour Suite. Now, Cheshire Police, in their infinite wisdom, decided not to investigate this case. You'd have to ask them why they did that. I assume because they thought for some reason it didn't need to be investigated because Lucy Letby didn't work on the neonatal Central Labour Suite. Therefore, it couldn't be malfeasance because Lucy Letby wasn't there. That's the most likely explanation, but we don't know why they didn't investigate the 18th death. However, we can look at the... it's difficult to look at this document, but that's the clearest I can make it. So, there's 4 infants. The 5th infant on the Central Labour Suite, we don't know anything about that at all. The 4 deaths that occurred at the hospitals, we don't know too much about that. And then there's various explanations given for the other infants in the case. How accurate these are, and initially Dr. Evans deemed some of these deaths to be suspicious. We know that now, we've seen the notes. There are certainly, this one in particular, congenital pneumonia with inflammatory response syndrome, and this one, prematurity with sepsis, seem to be very, very similar to the cases that were in the court case. So why they were ruled out, I have no idea. It's harder for me to comment on some of the other explanations because they're complex, and I don't think there's any reason for me to do so, really. But you can find this document yourself. It's available online, INQ0108782, and you can go through and look at what Dr. Evans decided were the explanations for the other deaths. But we can't look at 5 other deaths because no information exists and is confidential. Did Cheshire Police ever visit the neonatal unit itself during the investigation? I can't answer this question with complete confidence, but all of the evidence that I've seen indicates that they did not. I know that they interviewed a lot of people at Blackham Police Station, and it wouldn't be typical for them to obviously go to a hospital and interview people, and mostly what they were interested in doing was interviewing people from the hospital. And they did interview people. I know a few people that I know for a fact they interviewed that it's not common knowledge that they were interviewed. But I see no evidence that they visited the neonatal unit during the investigation, unless you count the 2021 filming of the neonatal unit when they'd already decided they were going to charge Lucy Letby and send the cases to the Crown Prosecution Service. Whether you could reasonably describe that as being during the investigation is debatable, but they went and filmed the neonatal unit. I don't think they did visit, in all honesty, but I couldn't say that with 100% certainty. Could those responsible for Lucy's imprisonment face legal consequences? Yes, absolutely. Dr. Evans is the most vulnerable, but there will be serious scrutiny of Dr. Brewery and Dr. Jayaram and possibly the other consultants. There will probably be scrutiny, well, not probably, definitely there'll be scrutiny of the executives, and that there will be an enormous inquiry into what happened at the hospital, into the Thirlwell inquiry, and into various other aspects of this debacle. Whether or not they would face legal consequences, I couldn't really say, but there's certainly a very significant possibility. Why has the Criminal Cases Review Commission not yet referred the case back to the Court of Appeal? Well, the answer to this question is that the legal system moves extremely slowly, and that actually the progress that's been made on Lucy's case is relatively quick. It may not seem that way as we're all waiting for it to be referred to the Court of Appeal, and hopefully that will happen soon. But the Criminal Case Review Commission does typically take a long time. Now, they would say in their defence that Barrister Mark MacDonald took quite a long time to waive privilege, and that's not entirely unreasonable. It was obvious that he would waive privilege. He's obviously done it strategically at what he believes to be the right time. I don't know why he made that decision. I'm not privy to that information. In terms of why the case is yet to go back, as I say, I can't really add anything other than to say that this usually takes a long time, but it will hopefully happen this year, and I hope that it happens in the next few months. It should be an absolute open goal for this case to be referred to the Court of Appeal. I'm sure that will happen, so the Criminal Cases Review Commission really cannot drag their heels and take a long time to do this. Now that Shu Lee has stated that the so-called signature rash is not indicative of air embolism, how will this be handled in future inquests? Well, typically, if we look at the history of these sort of investigations, and if we look at the history of medicine, I don't know that there have previously been many allegations, if any, of the causing of deliberate harm via the injection of air and air embolism, let alone air down the nasogastric tube. In terms of what impact that would have on future inquests, it should never be near the top of the list anyway. It should always be at the absolute bottom of the list for any inquest into anything, because it's such an unlikely reason for an infant to deteriorate, destabilise, collapse or die. So the only reason you'd look at air embolism typically would be if you'd ruled out all of the possibilities. Now, in these cases, there are such obvious clinical signs in so many infants. To say that the most likely explanation is air embolism is an absolute joke. And I hope I've demonstrated this by now, but I'm still going to be going over more in the future just to make it clearer and clearer and clearer how ridiculous this is. It's not a diagnosis even. It doesn't even qualify as the status of diagnosis. Dr. Evans didn't do a differential or exclusionary diagnosis. Not at all. He just searched for methods of malfeasance. We know this now from the notes that have been released, that have been leaked from the police. He just went around floating various methods of malfeasance, and then someone gave him a report from Jayaram, and then he started saying it was air embolism. There's absolutely it's not even close to being scientific, let alone medical. So in future inquests, unless they get someone in like Dr. Evans, who's very obviously a complete shyster, then I just don't see it would ever. I can't see that it would ever happen. And of course, it will be so heavily publicised because of this case. I don't think there's ever going to be another allegation in this country of someone deliberately damaging patients via the injection of air or an air embolism. This will absolutely kill this as an allegation. How could the same evidence that failed in a workplace grievance process lead to multiple criminal convictions? Well, at the time of Lucy's grievance procedure, that was towards the end of 2016, no evidence had been provided. The case was passed to the police with no evidence. We know that for a fact because it's in internal documents from the Cheshire Constabulary. So there is no evidence in the workplace grievance process. Ravi never said a single thing about the so-called child K tube extubation. So when this evidence was then appearing in the police investigation and then ultimately resulting in these criminal convictions, it was being heard for the first time. It didn't play a role in the grievance process, so that's how those two things could turn out very differently. Did Dewi Evans' air embolism theory rely on weak or non-medical sources? Well, firstly, it certainly relied on weak evidence because he said that he decided it was air embolism when there was a sudden collapse and they didn't respond to resuscitation, which again is an absolute joke. But we know why now because the paper doctor, the kind of opinion of Dr. Jayaram was passed to him by the police, and then he changed all of his opinions. Prior to that, he never mentioned air embolism, not once. So that tells you everything you need to know. In terms of whether they were non-medical sources, Dr. Evans likes to claim that he used 18 sources, but all of these other sources, apart from Lee and Tanswell, were case studies. They were not diagnostic. The only diagnostic source is the Lee and Tanswell paper. It's not that that's a weak or non-medical source. It's that he's completely misused it, and there are numerous reasons why what he's done has zero validity. I've explained these in many previous videos, so I'm not going to go over them all again here. But, for example, one of them is it just doesn't deal with the same type of air embolism that Dr. Evans alleges in the court case. That's pretty bad to begin with, but then there's many, many other reasons why his theory just has absolutely no merit. In Operation Hummingbird video, detectives said they had to decide between natural causes and murder. Why was medical negligence not seriously considered? So a lot of the answers to questions about the police are the same. It's because of ignorance and stupidity. They should have considered medical negligence. They should have followed numerous lines of inquiry. They just didn't. Why didn't they follow these lines of inquiry? Well, it's a combination of stupidity, ignorance, and incompetence. The incompetence emanates from their ignorance and stupidity. Now, you'd have to go into a deeper answer of why these Cheshire Police officers were so poor, why they're at such a poor intellectual level, and why they couldn't follow the basic policy and procedure that they should have done. That can be for all manner of societal reasons. Essentially, I think they are a reflection of what is something of a failing society. But I've spoken about that previously. I'm not going to speak about it in this video. I think I've answered your question. It's just simply gross incompetence. Are Lucy Letby's datix submissions publicly available? Some of Lucy Letby's datix submissions are publicly available in the Thirlwell documents, and I've had all of these examined by a neonatal nurse, and she concluded that Lucy was the most conscientious submitter of datix information on the unit. Now, we haven't seen all of the datix, unfortunately, and we probably never will. Thirlwell may have more available that it hasn't published, because I know they haven't published other documents, but we just simply don't know. How long does the Council Chester Hospital retain historical datix reports? So they should retain them indefinitely, really, because they're medical records, and medical records should be kept for a very long time. But there could be like an amnesty period. However, the only people that have the right to see them are the patients or relatives of the patients, next of kin, etc. So they could keep them for 1,000 years. It doesn't really make any difference. We don't have any right to see them. So we're never going to see these datix reports unless there is a massive inquiry in the future, at which point the state can order the Council of Chester to release them. But in terms of us seeing the datix reports or filing freedom of information requests and so forth, that's just a blind alley at the moment. It's a non-starter, I'm afraid. Has anyone conducted a full analysis of the hospital door swipe data? So, theoretically, Cheshire Police and the prosecution have done this, but as they reversed it all, whether you could reasonably describe that as a full analysis is debatable. Apart from that, we're very much hamstrung or limited by the fact that we have to go on what the police have provided. The police will not, again, release this information, as far as I'm aware. So we can't look at the original data, or it's very difficult for us to look at the original data, certainly. So all we can do is look at what the police said in court. So therefore, to actually conduct our own full analysis will be very difficult. I don't know what the defence are doing. I don't know if whether the defence are looking at this in any great depth, but I doubt that they are, because I think it's far more likely that their total focus is going to be on dismantling the medical evidence. And then maybe some of the circumstantial. They've got this gentleman, Shisley Good-Johnson, who's looking at the confession note and so forth. But I think the door swipe data and that whole portion of the trial, I've described it in my book as a hodgepodge of nonsense. It's just tracking all these movements that are all inaccurate anyway. Just so they can say, oh look, Lucy Letby was around at a certain point and maybe possibly she could have done just a load of rubbish. So as far as I know, no one will have conducted a full analysis, and I would kind of question the value of this to a certain extent. I think Lucy will be exonerated on the medical information and by showing the anecdotal evidence was very, very poor. I know the movements of people on the unit is part of that anecdotal case, but it's not an important part once you've dismantled. Really, Lucy's convicted on the shift chart, the confession note, and the inchilling cases. And then, of course, you've got to look at the other medical data. And that's what needs to be overturned. What responsibility did hospital management bear regarding maintenance issues and safety reports at the time? So this is a very good question. It's something that I've wondered a lot, and we've had some discussion of this, and people have provided information in the comments and so forth. So I think it's worthwhile to just dig into this a little bit deeper. So I'm going to go into this in some depth because it's something that we have covered, but I don't think we've ever necessarily covered it in the depth that I could have done. And it's an interesting aspect of the whole picture. Of course, this references the sanitary conditions on the unit, which were far from ideal. So I've asked the question firstly, in the NHS system, what responsibility would hospital management have with regard to maintenance issues and safety reports? Hospital management are legally and operationally responsible for keeping the estate, equipment and working systems safe, for running effective maintenance and risk management arrangements, for ensuring staff report safety problems and that those reports are investigated, and for escalating and learning from serious incidents, all under CQC, standing for the Care Quality Commission, HSE and NHS England expectations. This is Health and Safety Executive. What that means in practice: keep premises and equipment safe and maintained. So the Trust must plan, fund and deliver planned preventive maintenance, repair unsafe items promptly and be able to demonstrate stewardship of the estate. 2. Meet regulatory standards for premises and equipment. Providers must ensure premises equipment are clean, suitable and looked after. Management must show systems to maintain, and where guidance cannot be met, have contingency plans and risk mitigations. The Care Quality Commission requires providers to meet these premises and equipment and safe care standards. You can see a reference to a Care Quality Commission document here. Operate robust incident and serious incident reporting, investigation and learning. Trust management must run an incident reporting system, grade and investigate incidents, including triggering the NHS serious incident process when appropriate, notify commissioners/oversight bodies and implement corrective actions and system changes. Comply with health and safety law and accept board level accountability. Employers and senior managers are legally responsible for workplace safety under, for example, the Health and Safety at Work Act. Senior officers and directors can be held personally liable if failures are due to neglect or consent/connivance. Management must therefore have clear responsibilities, competent staff, and documented safety leadership. And fifthly, run local systems for reporting, escalation, and candour to patients. Practical duties include running a local incident system, e.g. datix or equivalent, ensuring staff know how to report, ensuring duty of candour communications to affected patients and relatives, and keeping incident records and action plans while showing audit assurance at director board level. Local trust incident policies typically set these responsibilities out. So you can see that from this that the hospital management would have quite strong responsibility, as you would expect, for issues related to maintenance and safety on the unit. So there's some explanation there regarding typical roles and lines of accountability from trust board chief executives. They're ultimately accountable for the estate safety. So although they're not the first port of call when it comes to being the eyes and ears of the unit, if there's sewage on the unit, they are ultimately responsible for that. Above the consultants, obviously above the nurses, above everyone. Then it goes down to Executive Director of Estates, Director of Nursing Medical, Director of Patient Safety Lead. So they would all have responsibilities when it comes to clinical safety, incident reporting, response and learning. And finally, Health and Safety Manager, Estates Manager, in this case, this guy Manzuti, who appeared in court, they would all have accountability and responsibility for the safety and sanitary conditions on the unit. So I then went on to ask the question, what would be the chain of command overseeing the above? So the answer is when a maintenance or safety problem is raised, it flows from the ward department through local operational managers into the trust executive team and board for assurance, with estates, facilities and patient safety functions operating in parallel, and for serious incidents or systemic non-compliance to external regulators such as NHS England, Care Quality Commission and the Health and Safety Executive. So before we go any further, this is a key point. So if there are serious incidents or serious concerns or systemic non-compliance, so all of those things would apply to what the consultants accuse Lucy Letby of doing, then they can go to external regulators. Now, they knew that. So when Dr. Jayaram says, oh, we had no idea what to do, that's just, it was pretty obviously ridiculous bullshit anyway. But come on, it's not difficult to find this information. Of course they would have known what to do. And they even told the police that they could have done whistleblowing and gone to the RCPCH or the CQC. They know that. But that never happened. It never happened with the sewage. It never happened with Lucy Letby. And that is just simply abnormal. So typical chain of command in terms of what might happen in a hospital in practical terms is that at the top you'd have the frontline staff and clinical team, whose job is to spot the hazard, make immediate safe choices and report on the local incident system. Then you'd have the ward department manager who confirms immediate safety actions, logs the incident, notifies on-call estates and facilities and starts local investigation. Then you have the estates and facilities team who will triage the fault, carry out urgent remedial work or arrange the contractors, update the incident record and perform risk assessment. And so it goes on. I won't read the whole thing, but then you have the health and safety manager, the divisional service manager, patient safety team, executive directors, chief operating officer, trust board, and finally external escalation if required. And there's some further explanation of what should happen, what each level is expected to do, and how things should be escalated. So then I asked, what to me is a very logical follow-on question, is what responsibility would consultants have for reporting safety and sanitary issues on a neonatal unit? And if they didn't report them, what systems are in place to detect such issues? So consultants are, as you would imagine, professionally and contractually responsible to act to keep patients safe. This means taking immediate clinical steps, documenting events, and reporting safety or sanitation concerns through the Trust's incident and escalation routes. If they don't, the Trust has multiple clinical, operational and regulatory detection systems, such as incident surveillance, nursing escalation, audits, infection control surveillance, estate checks, complaints, morbidity and mortality review, dashboards and external inspection that should pick issues up and trigger investigation. So in short, if the consultants don't say, look, we've got serious problems with sanitary conditions, we've got other serious problems, to the executives, there are these checks and balances that should ensure that they were discovered. So with such major problems as occurred at the Council of Chester, you would surely expect these issues to have been discovered by the executive. So that is one area where if they did know, which they certainly should have known, then you could criticise them for not responding strongly enough to what was very clearly sanitary problems on the unit. So as an explanation of what consultants were expected to do, I don't think we need to go through all of that, but again, it is set in stone and documented the processes that they should engage in once they know that there are problems with sanitary issues on a neonatal unit and indeed other issues. You notice the key role that datix is playing in this, and we've seen previously in previous videos that the consultants weren't particularly keen on datix, at least according to the nursing managers on the unit. And of course, I've spoken to other people and they've said this is not unusual for consultants who typically don't welcome being held to account by datix. Then we have here how the Trust will detect issues if a consultant does not report them. So they have various avenues, what described here as overlapping detection mechanisms. So nursing and ward escalation, routine safety surveillance, incident reporting analytics, morbidity and mortality and perinatal review, quality and safety dashboards and board assurance, patient complaints /PALS/families input, planned inspections and clinical audit, statutory health and safety checks, whistleblowing routes, commissioner/NHS escalation. And then the consequences if a consultant fails to report would be local investigation and HR disciplinary action, professional regulatory action, and system remediation. So it would be the most serious consequences. So ultimately, the idea that they could just brush the sewage under the carpet, that simply shouldn't happen, and one would hope it didn't happen at this hospital. As to why there was no action taken, we don't know whether that's the consultant somehow managed to keep it quiet and the fail-safe systems failed to pick it up, or whether the executives sort of tacitly accepted the situation and both are somewhat culpable. There's no way that they could argue that we thought we could mend and make do and muddle through somehow. That's just completely unfeasible. So I'm not sure exactly what occurred on this neonatal unit, but we can see now that there are many systems in place to ensure that things are escalating. Of course, we know for a fact that there were issues on this neonatal unit that definitely should have been escalated to management. And if no one did anything, or if the executives discovered that the consultants had failed to escalate things, frankly, that itself should be escalated for external investigation. So I will finish this video by answering the final two questions on this page, question 46 and question 47. Why did police not disclose two emails, one from Dr. Jayaram in 2017 and another from the baby unit manager in December 2016 about raw sewage problems? I don't have a good answer to that question. I don't know whether the police did that deliberately or not. We know they've run an incompetent investigation. It seems strange, some of the things that have occurred in this whole debacle, to say the least. It's very obvious from what we know about the police now, because this new Netflix thing, because of leaked documents, because of other statements that have occurred, because of expert comment that is now part of this process of examining this very obviously unsafe conviction, that Dr. Jayaram should have been... He should never have been allowed to do what he's done in the court case. It's incredible when you look at it that he never even mentioned this tube extubation, then suddenly, speaking to the police, he suddenly remembers and mentions it. I mean, that's an incredible situation in itself. So I have no idea what the police are doing with disclosure, but they've clearly not... It would appear they're not doing much to investigate Dr. Jayaram, because we've not heard anything more back from the police on the referral of Sir David Davis. And whether or not he can be convicted or charged with perjury, I wouldn't know. It's very hard to say, and I accept, and I've stated myself, it's very difficult to prove. But the conduct and the actions of Dr. Jayaram cannot be defended, and there should certainly be further investigation into what he did. And as to why there hasn't been adequate disclosure, I don't know. It's just not good enough. And finally, has Dr. Evans' 10-minute finding been tested by giving the same medical files to an independent panel of experts? So effectively, yes, because the independent panel that has presided over Lucy's... it's not Lucy's defence. They're now willing to act in Lucy's defence because they've examined the clinical notes and don't see any evidence of malfeasance. So clearly within 10 minutes they wouldn't have drawn any such conclusion, and they wouldn't have drawn the conclusion that there definitely wasn't malfeasance either. They've very, very thoroughly examined all of the notes and documents that are available to them, and the idea that a medic can decide in 10 minutes, or comments since then indicate they perhaps decided in less than 10 minutes, the idea that this can be achieved in any kind of legitimate way is ludicrous, and it's just one of the many countless litany of things that discredit Dr. Evans as a medical witness in this case, and it's very clear he never should have been allowed anywhere near this court case, or, in my opinion, any court case at all. So that concludes this question and answer session. Hope you've enjoyed listening to my answers. Thank you as ever for submitting the questions. I do have, I think, 25 left over for part 12 of these question and answer sessions, and I know I'll get many more questions in the intervening period. So, as always, any questions you have, whether now or whether you watch a video in the future, please do leave the questions, because they're all very much appreciated, and I try to find as many as I can. I get an enormous amount of comments now, and it's difficult to monitor everything, but I do the best job that I can, and I'll put together another list of questions for April, and then I will answer them. But if you have any comments, queries, or observations in the comment section, please do leave them, and thank you again for the interest and support, and I'll look forward to doing one of these sessions again in the future.